Well, I've been asked to talk about the question, as a pupil, did you have any difficult court experiences in your second six? And if so, how did you overcome these? Well, my name is Ed Hicks. I'm a barrister at Radcliffe Chambers, and I was called in 2004. So pupillage is something of a distant memory now. But I can tell you about a difficult court experience I had in fact, just after my second six, but the same thing applies. And I started out in practice doing a mixed practice, including some criminal work. And my first Crown Court trial was quite an experience. I was instructed to represent a gentleman in an attempted stabbing case. It was a 4-day trial. And he was a schizophrenic. I'd never encountered anyone with a serious mental health issue before. I'd had absolutely no training in how to deal with that. And the difficulty was that he had refused to comply with the requirements for a non-fitness to plead finding. So the judge had ordered that he was to have a full criminal trial. So there I was representing somebody who was a schizophrenic, who probably wasn't fit to plead, but because we couldn't prove it, was going to be in a full jury trial. And this, as I say, was my first experience of defending a full jury trial. So on the first day, the jury was called and we went through the usual procedures. The case was opened, and I don't think we got very much further than that. As I was departing, the client, now I should say the client had been remanded in custody, but the prison had transferred him to a mental health institution, and so he was being brought into the court by two nurses, although they were about 6'6", very burly gentlemen, every day. That was the plan. So he was being brought up not through the cells, but onto the main concourse of the court. And so at the end of the first day, I said goodbye to him. And he said, all right, I'm off to the pub. I'll see you tomorrow. And I said, I don't think you're going to go to the pub. I think you're going to go with these gentlemen, but have a good evening. And I left. Next morning, the prosecutor approached me and said, we've got a bit of a problem. You see, it turns out your client went to the pub last night, and the police chased him around the town, rearrested him, and he was then taken back to the mental institution where he was being held. They were refusing to bring him in themselves, and they'd requested a police van to go and collect him. The problem was he was refusing to get in the van. So the prosecutor said to me, right, you've got to make this call. We've got to get him here. You've got to call him, persuade him to get in the van. And the last thing you want to do on this call is get yourself fired. Well, sure enough, the last thing that happened on that call was I got myself fired, hence a pretty bad day in court. How did I deal with that? Well, I think I'd say the first thing is that when these situations occur, and they do, it's particularly hard because as a professional, you do actually care about your client. It's not just about winning and about yourself, but of course it's about being a part of that person's life in a very stressful and difficult time for them. That is a privilege, and caring about the result and about the person you're dealing with. And so that's what makes it particularly hard when something goes wrong. But fortunately, because these things do happen, and your colleagues at the bar and indeed on the bench are familiar with the fact that they do happen, you're not alone, and that is a very comforting thought. In fact, what happened in this case was we went back in to see the judge, who was very understanding, and he said to me, right, don't worry, just remain in court, take a note of what happens, I'll make sure you get paid, which was very good of him, and we'll continue the trial without your client, and we'll just see what happens, which I thought was a very generous approach for the judge to take. And so the trial proceeded, and there I was, sat in the back of the court, watching the victim being cross-examined by the judge in one of the least effective cross-examinations I think I've ever seen. Although, to be fair to the judge, he had absolutely no time to prepare it, and was, of course, trying to be neutral. Anyway, the next day, we turned up at court again just to see what would happen. And this time the client did attend. And he re-instructed us, myself and the solicitors, and we proceeded with the trial. And so this, what I would say in terms of how I deal with this, how I deal with these situations, is that actually the understanding of your fellow members of the bar and indeed of the bench is extremely valuable. It shouldn't be taken for granted, but don't underestimate the importance of it. In particular, I'd say at the criminal bar, I thought the camaraderie was much, much stronger than in other areas, perhaps because everybody is very much used to being thrown in at the deep end and playing the hand you're dealt, often at court with very little notice. But I wouldn't underestimate the importance, therefore, of the support that Chambers gives you, your colleagues, being able to unwind, talk about these things to your friends in Chambers. And that really does help, because they will inevitably have some story or bit of wisdom or advice that will deal with the situation. So I was very lucky to have an understanding judge who knew exactly what was going on. Don't underestimate the judge's ability to understand exactly what's going on outside the courtroom, and a sensible prosecutor with a degree of judgment and respect for his colleague who was in some difficulty. But we pressed on. That's the next thing to say about these situations, is don't give up. Even when things are going badly, you should press on if you at all can, because you never know what will happen next. And the third thing I would say is you never stop learning. In this case, we worked out, having not been in touch with somebody with schizophrenia before, we worked out quite quickly that his medication kicked in at about 12 o'clock. He was much calmer. We also, dealing with somebody with schizophrenia, you work out pretty quickly that much as there may be things going on in their mind that are fantasies, I learned very quickly that to them they are so real that when they talk about them, they can be very, very persuasive, because to them it is real. So in terms of a learning curve, that was very valuable, because we managed to get him on the stand in the afternoon on the third day. And as a result, his evidence was extremely compelling. He came across as very honest and genuine. And I don't know how much the jury had picked up. They must have had an idea that there was some sort of shenanigans going on. But in any event, he was able to give his evidence in a very effective manner that afternoon. And the following day, we gave our closing submissions, jury retired and acquitted. So press on is the next bit of advice. You never stop learning. And indeed, the experiences I had dealing with a client with mental health issues on that day helped me today. I'm no longer a criminal practitioner, but I deal with court of protection work, and I deal with contested probate work. And in those fields, we're often dealing with mental health issues, and an understanding of that was extremely valuable. I never had any training whatsoever at the bar school, or indeed really in pupillage, in dealing with those issues. So very much you are learning on the job. So I was fortunate. It all ended well in the end. But what I would say, and we all have bad days at the bar, if all else fails, 5 o'clock always comes. And think of the refreshers. I hope that's of some assistance. Thank you.